All right, welcome back for our next panel, which is SLAPPS Solutions. What action can the UK take to address SLAPPS domestically and internationally? I'm Rebecca Vincent. I'm actually stepping in on this panel for Jan Yaginsu, who had a conflict and couldn't make it in the end. But of course, he represents the high-level panel of legal experts on media freedom. In my role at Reporters Without Borders, one of the hats is sort of we serve as in an advisory capacity to the high-level panel. So he thought it might be a good fit. So I have big shoes to fill, but we have a great panel, so we'll get along just fine. So our panelists today will be the OSCE representative for freedom of the media, Teresa Ribeiro, who I can see online. Great, it's all working. Hello, Teresa.
Hello.
We've got Sarah. Oh, sorry.
How are you, Rebecca?
Doing well, thanks. I wish you were with us in person, but I'm really glad to see it's all working online.
Yes.
And we've got Sarah.
Reason for me to be here, far away.
Oh, of course. Well, we'll come to you first. I'll just briefly introduce the other two panelists. We've got Sarah Clark, who is head of Europe and Central Asia at Article 19. And then, of course, Charlie Holt of various SLAPP-related affiliations. And today, are you wearing your Greenpeace hat, your English pen hat? Yeah. Okay. So, but of course, many of you know Charlie for his active role in the various coalitions. So actually, we'll dive straight in because we've got a lot to get through in 45 minutes. So Teresa, maybe we can start with you. I know your office has, of course, looking at this from the perspective of the OSCE region, which is largely across Europe, but also the US and Canada. What do you see as sort of the situation, how the UK fits into that, and how is your office engaged to counter SLAPPS?
Much, and it's really a great pleasure to participate in this conference on such a topical issue as SLAPPS. I'm joining you online from Ucha in Poland, where I am for the annual meeting of the Ministers of Foreign Affairs of our organization, the OSCE, the Organization for Security and Cooperation in Europe. And what is interesting is that 4 years ago, at the very same occasion, the 57 ministers of the participating states, they adopted an important decision regarding the safety of journalists on a broad range of topics, including some relevant for today's topic. For instance, in that decision that the ministers adopted, they show themselves deeply concerned by all human rights violations and abuses committed in relation to the safety of journalists. And just allow me to quote, intimidation, harassment, and threats of all forms, such as physical, legal, political, technological, or economic, intended to suppress their work. They also condemn publicly. All attacks and violence against journalists, such as intimidation, harassment, and threats of all forms, including, and this is important, physical, legal, political, technological. So it's a very interesting decision because it's very broad and it's very comprehensive in all the dimensions that are related to the safety of journalists. And they call upon the participating states, and again I quote, to bring their laws, policies, and practices pertaining to media freedom fully in compliance with their international obligations and commitments, and review where necessary, repeal or amend them so they do not limit the ability of journalists to perform their work independently and without undue interference. So it was really an important political commitment, and it's very clear that the use of legal instruments and procedures to harass, intimidate, or stifle journalistic work is, in their view, in stark contradiction to the safety of media workers, and at the same time is really in contradiction to the various OSCE principles and commitments on media freedom that were adopted by the organization. So, but these are political commitments. They are very important, of course, but unfortunately, their implementation is sometimes very different. I do not have to tell you about, the different cases in various parts of our OSCE area, which is a very broad area that ranges from Vancouver to Vladivostok, and legal harassment and the abuse of the judicial system to suppress the work of journalists can be, unfortunately, witnessed all over. And it is another very powerful tool in the box of the ones who really want to silence critical voices and stop the media from doing their work. It comes in many forms, this kind of risk, from administrative sanctions, criminal prosecution, but also the threat of expensive civil litigation by powerful individuals and organizations. So the effects can be really devastating and posing a serious threat to the safety of media and to the economic basis of the outlets. And this is why this is really so serious. All my predecessors as representatives on freedom of the media and myself, we have always advocated for the repeal of criminal defamation laws. Defamation definitely should be in the realm of civil law. We have always argued and not in the criminal law. And for good reason. It is shown every time a journalist is being prosecuted on the basis of defamation claims. But the problem is this is only part of the answer. First, because civil law is unfortunately also very much prone to be misused. Even in countries where defamation is no longer a criminal offense, the law and the judiciary are used to stifle media workers or, in many cases, retaliate for their doing their work through lengthy and expensive civil suits, which, as I mentioned before, has a very, very negative impact on media freedom. At the same time, this kind of misuse is much broader than defamation cases alone. And nowadays we have privacy law, terrorist charges, accusations of contempt of court, or hooliganism, or torts, labor law. So it's endless, the creativity of those who really want to abuse the law. And, which means that we need a more comprehensive answer to these threats. And as the representative of an autonomous institution within a security organization and with a wide membership of, as I said, of 57 participating states, we have enormous variety in legal regimes. I'm aware that a one-size-fits-all solution, it's impossible to provide. So my contribution depends on the wise use of the means at my disposal. And among these means, I would, in a way, underline or highlight the right to the pulpit, the direct access to political level, or a tailor-made assistance to the states. And these are very important tools and means and resources to use as a diplomatic push and political will it can really contribute for visible improvement. When visiting Malta, when speaking with Italy, when addressing Serbia, just to name a few OSCE countries, the legal harassment is always on the list of issues for us to discuss. And this is the reason why I decided to publish a special report on this issue last year. It's in our website, so please have a look on it. Aside from monitoring and discussing individual cases and the overall system, as well as ensuring assistance, I can also provide the OSCE states with a platform where they can share their practices, best practices, their examples, their difficulties. For instance, through one of the next roundtables in our new project of safety of journalists. Somewhere in the spring next year, we will gather experts from all over the region and the participating states to discuss the problem of legal harassment, but more importantly, the idea is really to find ways forward, learning from the different experiences that we can share. And this brings me to the specificities of this conference. It's the urge and the willingness to find solutions to the issues of SLAPPS in the UK. And this is highly relevant with the UK being an OSCE participating state. It is relevant because the UK has a particular legal system that provides much space for libel lawsuits, including ones with a cross-border aspect. So this is the reason why I'm so interested in your conference, to hear from you, to the better of the situation in the UK, but also to learn your lessons that can be important source of inspiration for other participating states in the OSCE region. I would say these are my first remarks.
Thank you so much, Teresa, and would certainly encourage everybody to read that report, which is a great basis to take this forward in a broader way throughout the region. And I think maybe a bit later in the discussion, we can come back to this question of the connection to safety of journalists in particular. But I'll turn now to Sarah Clark. And Sarah, Article 19 has worked extensively on this, particularly at the level of the Council of Europe. Do you want to tell us a bit about your work there?
Yeah, so as part of the Coalition Against SLAPPS in Europe, we have been doing a lot of advocacy at the Strasbourg level to kind of match the Brussels advocacy, which we've been doing around an EU directive. We were particularly inspired by the recommendation on the safety of journalists, so the 2016 recommendation, and the other recommendations of the Council of Europe, which are the sort of highest set of legal standards, really, when it comes to issues pertaining to the European Convention on Human Rights, so Article 10 in particular. So a group of us started a little advocacy, Charlie included, and a number of others, toward the Council of Europe. We began to, so as to generate the interest for them to commit to a recommendation. In doing so, we used the Council of Europe platform on the safety of journalists, which some of you may know. That's a great venue if you have SLAPP cases, because you can register cases against that take place within specific jurisdictions, and it's an obligation of the member states to respond to those alerts. So we really encourage people to use that. On the basis of those, we did an annual report section, and the Secretary General of the Council of Europe started to take an interest in the issue of SLAPPS. And this sort of all culminated last year when the very catchily titled name, the MSI SLP, which is the committee who are now drafting the Council of Europe recommendation on SLAPPS. where we are with that recommendation is we have a first draft. We'll see a final draft sort of end of next year. So these are extremely detailed international standards reports. And we know sort of from the Secretariat and along with a number of our colleagues who are on the expert committee there, they're really focused on the widest possible set of standards here. So we had comments earlier today and again from the representative just on how SLAPPs often cover both criminal and civil law. So we're having a really deep dive into kind of the intersection of the various laws, along with the widest possible set of actors who are targeted by SLAPPs. And what's important really on that expert committee is that we have the participation of the UK. And I think in particular, and the representative sort of alluded to it, the UK is the hub of cross-border cases. The role of UK or English and Welsh law in this is extremely important. It's also something that's often poorly understood, maybe on continental Europe. So it's been really crucial to have the UK's that their participation in this it has been really important. So what we're really pushing for, obviously, number one is that this recommendation complements the work here towards the adoption of an anti-SLAPP law. So that's obviously like the number one issue that we want to see. But in terms of non-legislative solutions as well, that they're being articulated both through the Council of Europe and other bodies, we see other elements that we'd really like the government here to take on board. So in particular, those relate to full transparency and publicity around cases that are found to be SLAPPs. We see the Council of Europe recommending that public registries of cases are established, and that this will be important that these include the names, the legal or natural names of those individuals who are filing the cases, the law firms who represent the applicant, etc. So to have really strong data on these cases is really important. We also see, again, this is all kind of in line with European Court standards. We want to see support for SLAPP victims. So that includes, legal support. There's been a lot of talk about whether defamation and SLAPP cases in the UK, you could have recourse to legal aid. And I think we'd see that as particularly important, particularly because the costs issue is so huge here. We also see kind of from the recommendations that the idea of having financial support to journalists whose work is interrupted because of SLAPP cases. Carol spoke this morning very movingly that she's published one article or something this year because she's been so taken up with the cases, and so we see that as something that we'd really like the government here to engage on, is that sort of direct, financial support, whether that will be through the Union of Journalists or otherwise, but that there's real recognition of the financial implications for journalists. Council of Europe is also recommending psychological support. So we're talking about having access to confidential and professional psychological support. And, they've gone into, some detail really around ensuring that public health authorities have a mandate and resources and can pay special consideration to SLAPP victims. So it's kind of, that level of detail that we're beginning to look at. There's also the element that has, we've seen that's particularly important around education, training and awareness raising. So the issue of training for judges, training for prosecutors and for lawyers around SLAPP issues. And that's something that the Council of Europe does in relation to other Article 10 related cases, but we'd love to see that, specifically on SLAPPs. And so we see a real role for the UK and the Council of Europe together to do this sort of training. Turning just for a moment to the the mechanism here for the protection of journalists. So we saw the establishment by DCMS in March of last year, of 2021, of a national the protection mechanism for the safety of journalists. And while we really welcomed the focus of that mechanism on the physical safety of journalists, and there was also the element of online harassment of journalists, so far the mechanism has been silent when it comes to SLAPPS. We'd really like to see that, expand to the inclusion of SLAPPS as a very serious threat to the safety of journalists. And also because this would enable us to have an effective monitoring mechanism in the UK of SLAPPS against journalists. Part of the remit of the mechanism is to monitor threats. So we would see, the inclusion of SLAPPS is particularly important. So for anyone from TMS WTCMS who might be here or working on that national mechanism, we'd really like to see both the collection of data around SLAPPS, but also the signposting of other solutions. So, whether that's the SRA's warning notice and how you could then engage with the SRA or apply for legal aid or other issues around SLAPPS. So those are just some of the areas where we see this interplay between the Council of Europe's recommendations and what we'd like to see maybe more on the ground here in the UK.
Sure. And just a word maybe on the National Committee on the Safety of Journalists, because at Reporters Without Borders, we have a seat on the committee, which we have engaged with from the start. And indeed, the creation of the committee and the first National Action Plan for the Safety of Journalists were welcome steps. But I'd say from the civil society perspective, the jury is still out about the effectiveness of this committee in actually reducing threats to the safety of journalists in this country. I think more is definitely needed in terms of real action. And so far, our efforts to advocate for the broadening of the focus to include SLAPPS as well were not successful. So just to put a question mark there, the existence of the committee and the action plan, great. Let's see in terms of implementation what this actually does for safety of journalists in this country. So we've heard about OSCE standards, Council of Europe standards, and of course the UK is a participating state in the OSCE, as Teresa Ribeiro mentioned, and in fact a Council of Europe member and one that is obligated to respond to alerts through the Safety of Journalists platform. So the UK is perhaps placed in those bodies to set a good example and to hold peers to account, but how is the UK performing itself? So I'll bring in Charlie because I think he's done a bit of a report card in terms of the UK's own performance when it comes to SLAPPS.
That's right. Thank you, Rebecca. I mean, in answer to the question, what action should the UK take domestically, we've given a firm, emphatic answer already, and that is pass the model UK anti-SLAPP law. But I'm not going to go through that all again. We did cover in detail yesterday. If you haven't read it yet, please do read it. I'm not sure if we still have copies available. It's on the website. It's a documented fact that it took us longer to write this than it took Charles Dickens to write A Christmas Carol. That is a fact. So please do give it a read.
Charles Dickens wasn't a lawyer.
That's a very good point. No, instead, as Rebecca has said already, what I'd like to do is it is the last session of the day. It's we're approaching Christmas and the new year, so I thought it'd be appropriate to do an end of term scorecard for the UK and its delivery on the goals that we set out for SLAPPS. And we are going to do this by taking a little trip down memory lane to July of last year. I alluded to it yesterday, but the UK Anti-SLAPP Coalition published in July of 2021 a policy paper. It's in the book. You can find it here now. This policy paper identified the conditions that give rise to SLAPPS. As I spoke about yesterday, this was based on us studying cases in the UK and in Europe as a whole. It gave us a really clear idea about why it was that some countries like the UK have proven to be a more fertile territory for the emergence of SLAPPS. I'm going to go through these, and I'm excited to say that I think for the first time in this conference, there will be slides. I wonder if we can put those on. There you go. These are, thank you very much. If you could just go back so I can show them. We're giving it away. There is a lot of spoilers going on here. If we could, well, there they are. It looks like we can. Thank you very much. These are, yeah, we're getting rid of them. So 5 conditions that we identified, we refashioned as principles, because any effective measure to tackle SLAPPs and to deal with SLAPPs comprehensively will work to advance these 5 conditions. So I'm going to go through these quickly, starting with the first of these, which is that SLAPPs are disposed of as quickly as possible when they reach court. We spoke about this yesterday, about how the existing mechanisms we have for disposing of cases early are inadequate in the context of SLAPPs. Judges are understandably reluctant, without any judicial guidance, to dismiss cases on the basis of an inferred improper purpose, which would be abusive under existing case law. But likewise, the test for summary judgment is for the burden lies on the defendant to show that there is no real prospect of success. Simply put, that the claimant has some prospect of winning at trial, that it's not entirely fanciful. This is obviously far too easy a hurdle for those who file SLAPPs to have to overcome. And that's why we've called for a robust early dismissal mechanism. And that's why you'll find that one of the core components of the MOJ's proposals is for an early dismissal mechanism. Unfortunately, their proposed mechanism uses that same existing test of real prospect of success, which is why that really needs to go higher. I'm afraid unless it does go higher, the UK is not going to score more than an E grade here. So it's important that they do follow the model law on that basis. The second condition, if we could move to the next slide, thank you, is for costs for SLAPP targets to be kept to an absolute minimum. Again, something we've spoken about after the last 2 days. The first priority here is that those who are targeted by SLAPPs have the financing necessary to fight the SLAPP, and not to simply have to retract before it gets any further to trial. How is this done? Well, the most obvious means is through legal aid. We spoke about the potential for expanding LASPO to include defamation claims, or at least claims targeting acts of public participation. I think it's interesting to note that one of the few SLAPP cases to reach the European Court of Human Rights is, of course, Steele and Morris against McDonald's Corporation. And that, of course, found there that the UK was in violation of Article 6 on the basis that Steele and Morris were unable to mount an effective representation in court. And that was on the basis that defamation, legal aid is simply not available for defamation cases. But the UK subsequently introduced what's called exceptional case funding for cases where human rights can be violated in the absence of legal aid. As far as I know, and I see Mark here, so I'd be very interested to hear whether he knows of any cases, we haven't been able to find any cases where ECF has been successfully applied for in a defamation case. And of course, there are other cases with other laws, but we've had a similar point. This is really important. Now, it might not be that legal aid needs to be expanded. Maybe there can be a state funding for SLAPP victims. Maybe state-sponsored insurance regime for those who are targeted by SLAPPs. Whatever it is, it will cost money. And unfortunately, at the moment, we don't have a government which is minded to spend money. There are other means, however, that we've looked into which can address this problem of cost and reduce it. And that's why you'll find in the model law proposals for reducing the cost of the disclosure process, which is notorious, as we've heard from Carol Cadwallader, for being the most invasive and being the most resource-intensive part of proceedings. If we go to condition 3, please, and I'm wary of time. Costs for SLAPP litigants need to be sufficiently high to deter SLAPPs. What does the UK have already? Well, we have a cost-shifting regime whereby the winner is responsible for paying the costs of the loser. This is always limited. It is most generous when costs are ordered on an indemnity basis, but this is very rare. It's a very difficult hurdle to claim. You have to show unreasonable conduct to a high degree. And what we're saying is that this needs to be available for every SLAPP case. So there is greater guarantee that all fees will be recovered at the end of the process. Is this going to be enough to deter SLAPPs, even if this was introduced? No, is the simple answer. We've seen in the US, for example, the big corporations and powerful individuals are able to easily absorb the costs, even when they have an adverse cost order against them. And that's why we have, in addition, caused for sanctions to be imposed, which we've introduced as a form of exemplary damages. we could go to condition 4, the penultimate condition or principle here. So laws implicating speech are narrowly drafted and circumscribed. This recognizes that some laws are more amenable to abuse than others. We obviously know the prime culprit here, it's defamation. We found, for example, in the Coalition Against SLAPPS in Europe, in the research was produced for case, that 90% of SLAPP cases involve defamation claims. We, the UK Coalition, in our submission to the MOJ, outlined ways that defamation law could be further reformed. It was interesting that Carol spoke at the beginning of the day about the single meaning rule. So we raised ways that could be reformed. Dr. Andrew Scott was referred to yesterday in the context of Northern Ireland. He has put together a very compelling solution to that, about a bifurcated approach which would abolish the single meaning rule while at the same time providing means for for meanings to be easily corrected, and a jurisdictional bar for those who do correct. Sorry. Either way, there needs to be further reform of these laws, not just defamation, but other laws which have proven to be susceptible to abuse, whether that's copyright, data infringement, Protection Against Harassment Act. There are numbers. All of these need safeguards built into the law, and we need to stop having a proliferation of laws which are amenable to abuse, which means we need to stop having so many laws introduced with implications for free speech. Maybe just the final condition here, principle. This is really important. It is the notorious cultural conditions. We know that in some countries in Europe, for example, there are laws which are very badly drafted, can be easily weaponized against public watchdogs, but they're not. And this is largely for cultural reasons. To some extent, we benefit from these cultural conditions. In some parts of Europe, in Poland, for example, in Italy, in Malta, of course, we see politicians using SLAPPS as a means of responding to criticism. Fortunately, we don't tend to see mainstream politicians do this. We see people like George Galloway doing so, but doesn't tend to be heads of parties, for example. That's cultural. But unfortunately, it is still regarded as a legitimate means of responding to criticism if you're a big businessman or a corporation. We need to work on delegitimizing that. But of course, we also need to work on delegitimizing SLAPP tactics, the way that some lawyers facilitate the use of SLAPPs and use certain tactics which are designed to stretch out proceedings and harass those they target. And that is why, and I'm going to finish on this, what the SRA did yesterday was so important. And it was such a crucial first step in publishing a warning notice and providing greater specificity as to what activities would be regarded as abusive. That could set an incredibly significant precedent, not just here, but across Europe. And I think that's why I'm going to end on a positive note and say, in this regard, I think the UK deserves a B, but that is down to the SRA, and certainly across the board, room for improvement. So I'll stop there so that we can have some questions, but hopefully that clarifies some of those points.
Thank you. Super useful, Charlie. Just to say, for those following online, if you would like to ask a question, you can type it into the comments and I can see it here on the stage. But for now, I'll look to the floor here. Does anybody have a question to put to the panel? Don't be shy. Okay, I will make one comment that I know that Jan would have liked to raise, which is also related to another body, the Media Freedom Coalition. The UK was a founding member of this body, in fact, and this is why the high-level panel of legal experts on media freedom came into existence, was in parallel to this. So the panel itself has a series of reports on various areas of media freedom, including some that can pertain to SLAPPs as well. And so I think one thing that we would raise as well from civil society side is the need for implementation of the excellent report recommendations that have come out from the panel. Thinking off the top of my head, some pertaining to safety of journalists also apply here to SLAPPs, such as perhaps even the recommendation to establish emergency visas for journalists. I can envision situations where someone may need to flee a jurisdiction quickly, and we need better tools from states who care about media freedom to actually allow journalists to seek refuge. And that is not something that this country currently does very well. So I will look online. I think it's the end of a very busy 2 days, and maybe everybody's asked all the questions. We have one. This is actually a question for the panel, and I think maybe, Teresa, we've still got you online as well. Great. I'll take this to you first then, Teresa. What key developments would the panel like to see having happened by this time next year? So is there sort of a plan of action going forward from your perspective?
In our case, it's really our project on safety of journalists. As I said, we had this decision on safety of journalists adopted by, which is a strong political commitment as it is adopted by consensus. So this is really the framework. Of course, we know that one thing is the adoption of such commitments, and the other completely different is, of course, the implementation. But let me just add something which I think is important. First of all, I think that we are now talking about SLAPPS much more than a year or 2 years ago, and this is very positive. So suddenly SLAPPS became a very pervasive subject in our media community, with impacts that goes beyond this media community, and this is very important. And why so? Because media freedom is now. It became very important at the geopolitical stage. I think this is also important to underline. So we are, because of the war, because in a way information and freedom of the misuse of freedom of expression was engineering the war and the invasion of Ukraine. So I think that politically we are in the right moment. At the same time, I think that we need to be aware that we need not only a broad and comprehensive approach, but at the same time a multi-layered, because we need, for example, the European Union is thinking about having a directive on SLAPPS, but only in the trans-border cases. So it means that it has to be complemented by national legislation. So it's national, and then it's also international. So this is one point. The other thing that I think is also important is that we need really to be aware of all the actions that we need to take in order to ensure that the issue that we address properly the issue of SLAPPS. And for that, again, we need collaboration between all the institutions, all the organizations that are working on the subject. It's not a subject for us to compete, but on the contrary, really, we need to join forces. We need to see where we can bring added value. So connect the dots is also very important. And we need, for example, to work very closely with the media representatives. This is because they are, and the other stakeholders. I don't know who mentioned, I think that it was Sarah or Charlie, I don't remember, sorry. But the training for judicial this is very important, and we have a judicial dialogue in our institution, in different regions of OSCE, and again we need to put SLAPPS also in the agenda of this judicial dialogues that in the end is a kind of a training for judges of different regions at the OSCE. So there is a lot to be done at many levels. And definitely we need to put all this together and try to have an effective impact on SLAPPS and having an effective impact on the way we address this threats to media freedom and the work of the journalists, of course.
Thank you so much. And actually, I'll take the same question to Sarah and Charlie. What do you see as the way forward? What are the next steps in improving the situation?
Well, I mean, I think Charlie and I be on the same page. I think number one, we need to see an anti-SLAPP law introduced here. That's absolutely the most important thing. On the Council of Europe level, this time next year, they'll be finishing up the recommendation. It'll then go to the Committee of Ministers who need to adopt it. So we'd like to see the strongest set of standards going through, and we'd love to see the UK really championing the strongest set of standards at the Council of Europe level. And then just a quick note on the National Committee for the Safety of Journalists. We'd like to see SLAPPS included in the National Action Plan. It's really important that SLAPPS are given the same level of attention as other issues relating to the safety of journalists.
Charlie, any final thoughts?
Yes, I'd certainly start by agreeing that the most important thing is to see the model UK anti-SLAPP law become a reality. Doesn't need to be word for word. They can change the font size, but the content needs to be there. I just also say at this point that, and maybe we can close here on this note, which is that this time last year, so many of the things that we were talking about have now become a reality.
Yeah. So
we can be ambitious about this. I mean, the idea that, yesterday we saw the publication of the warning notice. If we saw that last year, we would have thought that would have been pie in the sky thinking. But there's been huge progress over the last year, including with the fact that the MOJ has, even though its proposals in many ways fall short, it has identified the core components of an effective anti-SLAPP law. We'd like to see that being fleshed out into something meaningful. And then I'd just say there is so much else that we can do. We don't need to rely entirely on the government or the SRA or the BSB. There's lots of things that we can do to advance the last of those principles, which is the cultural condition, the delegitimization of SLAPPS. If any law students are watching this, we can see law societies being set up in law schools across the UK. That would be great to see. It would be great to see more corporations speaking out about and taking a more constructive approach to criticism and calling out SLAPPS when they emerge. There is a lot that can be done and a lot that I'd like to see done in the next year. But yes, number one is obviously that model UK anti-SLAPP law.
But you're absolutely right. It's not just on states. So I think maybe we end on that call to action for other stakeholders, whether it's civil society, whether it's journalists who are targeted, activists. I hope it's clear from conferences like this, from coalitions like these, that now there is recognition of this as an issue, as a threat to free expression and many other rights. There is solidarity. It's becoming safer to speak out. And, we're so moved by individuals like Carol Cadwallader and the personal experience she shared this morning. I think the more people like that are fighting these battles, the easier it gets for everybody else. And Carol ended this morning by saying she hopes she's the last journalist in the UK to be targeted in this way. We hope so too. So thank you so much for this important conversation. And again, to the hosts of our conference, the Justice for Journalists Foundation, Foreign Policy Centre, Andy Barry. And I understand that after this panel, there is not a break, so please stay in your seats. And I believe Maria Orjanakidze is going to come introduce the next and final speaker.